Welcome to Partnered Up Business Law, Deals, and Dynamics.
Hey everyone, welcome into an all-new episode of Partnered Up Business Law, Deals, and Dynamics with Jeffrey Fink, a partner over at Corin Lichtenstein, LLC. I am your host, Mike Leon. You know, Jeff has been advising business owners and partners on formation, growth, and dispute resolution for closely held companies. And in today's episode, we're going to be talking about buy-sell agreements and why they usually don't get that much attention until something goes wrong. Something always goes wrong. Jeff, it's good to see you as always. So let me ask you about buy-sell agreements here at the onset. 30,000-foot overview. How do they work?
So first off, thanks for having me again. It's good to see you. So what's a buy-sell agreement? Operating agreements, shareholders agreements, often will have provisions where there are circumstances where one owner can buy another owner out. But when people talk about buy-sells, they're usually talking about what happens if somebody dies. And sometimes it's set up so that the company can buy that person's interest back. Sometimes it's the other owner's buying directly. Sometimes it's a third party. There's some tax issues with that we can talk about in a minute. They can get really complicated if there are multiple owners and there's somebody wants to move ownership interest around after death, so it's not just everybody buying pro rata. A lot of the times it's funded at least partially by life insurance. It's called key man insurance or key person insurance or buy-sell insurance. And like estate planning, people don't like thinking about it.
You know, Jeff, you mentioned estate planning. I was thinking prenuptial agreements, right? When you think of buy-sell agreement, hey, we're going to be in this for forever. But we talked about this in a previous episode. What events usually force the partners to finally look at some of these buy-sell terms up close?
Well, prenup is a great analogy, and I don't always recommend that people enter into prenups. I do recommend that they think about buy-sells or what happens if somebody dies. So first off, it comes up a lot of times when people are doing their estate planning, and the estate planning lawyer will say, hey, you have this business interest. What happens? If there are joint owners of a business that I'm involved in setting up or modifying the terms of, I always recommend that people think about it, because the easiest way to do it is if something's automatic like that, there's just a list of things you have to think about, then nobody's buttons are going to be pushed. And buttons get pushed when people start thinking about their own death or the death of their friends who they're in business with. So some of the questions to ask, basic questions, are, do you want this ownership interest to be inheritable, or do you want to have it, would you rather have your estate have some cash? If you do want it inheritable, depending on where you are, it may trigger some estate taxes. In Massachusetts, there's a $2 million threshold now, which, if you own a house and you own a business interest and you have a little bit of savings, you may well be over that. Who's going to pay the estate tax if you don't have cash coming in? And then if you're the survivor or one of the surviving partners, you have to ask yourself, do I want to be sitting at a board meeting with the kids of my former partner who happen to be her heirs? The answer to that question is almost always no when you ask it. So again, it's important to think about it.
Can I ask you, where have you seen these buy-sell provisions kind of break down when the partners are relying on them? In your experience, where have you seen those?
Good question. The three areas that they break down in the most are, one, if there's just not enough details or the details kind of don't work. If there's too much ambiguity, people will just try to exploit it, maybe. As we'll talk about it in a few minutes, the way the interest is valued can be a huge issue. So we see three main problems come up. One of them is just where the details just aren't detailed enough. If there's ambiguity somewhere, somebody may try to exploit it. And that's something that you can control in advance. As we'll talk about in a minute, the way that an interest gets valued can be a huge issue. If the valuation doesn't match up with what people's expectations are or what the snapshot of the business reality is at the time, it may not work. People will fight over it. Um, and then probably most often, there's just not enough money. So the agreement says, with two partners, partner A dies, partner B buys that person's interest out. Even if there's some buy-sell insurance there may be a gap. The company just won't have the resources to fund. And question is, does it borrow the money? Does it pay over time? What are the terms? And if that stuff's not spelled out in advance, people fight over it.
Jeff, off air, we were kind of talking about tax concerns. I want to bring it over here because I'm sure that's a really important issue in these buy-sell agreements about the taxes, how they're structured, how they're funded. What is it? Explain first off the concerns. What is it, and how do people get around it?
So, with the caveat that I'm a business lawyer and not a tax lawyer, the tax treatment of these things has changed hugely in the last few years, and in a way that taxes now really drive the way these things are structured much more than they used to. So a few years ago, the U.S. Supreme Court weighed in with a case, I think is a pretty poorly thought out case, about the way insurance gets treated. It used to be that companies would have this buy-sell insurance. Somebody died, they would use the proceeds to pay the person out. All would be fine. Everybody would get an increase in equity ownership pro rata. But the Supreme Court said that now when you're valuing the interest, which you have to do for estate tax purposes anyway, you have to count the insurance as a company asset. So sorry if it starts to get a little technical here and even a little mathematical, but you have to count the insurance as an asset, but you can't count the obligation to pay those insurance proceeds out immediately as a liability to offset it when you're doing the valuation. So you're not really balancing things out. It doesn't reflect the real world treatment of this stuff. But it's a position the IRS had sought for years, and they found a sympathetic ear this time. So here's an example. And again, sorry for the math. Say you have, just to make it easy, you have two owners. Company is really worth $2 million. So company buys $1 million of insurance on each of the partners so they can fund a buy-sell if somebody dies. All makes sense. It's the way we used to do it. But now, when one of them dies, according to Justice Thomas, the value of the company is $3 million because the company is receiving $1 million of insurance proceeds, which means if you're going to buy somebody out, you really need $1.5 million insurance to buy them. But if you have $1.5 million of insurance, that means the value of the company, according to the Supreme Court, is $3.5 million. So you need even a little bit more to cover it, and so on and so on. And so what do you do about this? Either the companies have to absorb whatever the valuation differential is from their own other resources, or you set something up for the other individual owners directly or indirectly to own the policy, receive the proceeds, and be the buyers under a buy-sell. And there can be a lot of complications about that. We're seeing more and more people setting up separate entities like LLCs or trusts to own the insurance, with independent managers to make sure it all works. And you have to work closely with the estate planning attorneys to make sure that insurance isn't included in people's estates. And so, yeah, so it's all tax driven now, which means they're more expensive to put together, and more complex, and more complexity means more room for problems to come up.
Speaking of complexity, and I love that you gave math in round numbers. If you're going to do math, you got to do it in round numbers. But let me ask you, can you walk us through, again, without giving specific details, kind of a situation where we did have a buy-sell agreement in place, but following it turned out to be a little bit more complicated than anyone expected? Do you have some examples you can share?
I do have an example, and examples make this stuff real, because it's all kind of I don't know, it's all kind of abstract stuff, but I promise no math in this one. So the company had a bunch of shareholders. Company had a buy-sell agreement in place, which is great. There was some kind of formula in there to figure out what the price was, which in this case, the formula kind of worked. The problem is that the company had done really well and they hadn't kept up with their insurance, and the purchase price was way more than the company had assets to cover, even with the insurance covering the piece. There was language in the agreement about payments over time, but the company actually couldn't afford that either because the payments were more money than it had, and the language wasn't great there either. There was some questions about what the payment terms would be, and then to complicate things further, the people who were going to end up being the survivors owning the company were fighting with themselves about who would own how much after the fact, when the majority shareholder died. That was, not only an extra layer of complexity, it was, an extra layer of negotiation for people to do. And so it took a long time to figure it out. The person who was being bought out, the majority shareholder, got a diagnosis with a pretty bad prognosis. He was given 3 or 4 months to live. And we've been talking about fixing this up before, but suddenly it became real. Uh, and, uh, the people who he thought were his friends, who he was in business with, weren't really his friends. They saw some money and they started grasping for it in ways that the contracts may not have allowed. And fortunately, he ended up living for a long time. The chemo worked really well. He was around for over a year, but he spent 10 months, 11 months trying to work this stuff out. And I actually think that worrying about this and wanting to get this done and leave things clear when he passed away was one of the things that kept him around. He just held on just to make it work. But the problem is that's not what you want to be doing in the last months of your life. It's just not. So it could have been fixed if people worked on it beforehand, but it wasn't.
It's a tough story, and I'm glad you gave the example because it does funnel into a really good follow up. So, in that example, you mentioned about some of the agreements. Let's talk about how does a poorly designed one kind of change the tone of the dispute compared to one that was actually thoughtfully negotiated? Maybe like in this scenario that you just gave.
Most of the time, people will work things through. They really will. But sometimes the sharks circle and they smell blood. And money can do weird things to people. No question about that. Keeping in mind that nothing's perfect, you can think of a lot of ways to do things, a lot of different formulas for picking out valuations. None of them are going to work all the time. So, I'll give you an example of that. What people used to do is they used to say, well, we're going to sit down and we're going to agree every year on what the buyout price is going to be. And we're going to stick it as an exhibit to the agreement. And every year it's going to be there. So we'll have that to look at if somebody passes away. Problem is people never look at it. And they don't follow up with it, and it doesn't match what the business is. So that's, in most cases, going to be a poorly designed agreement. So my suggestion is the more detail, the better. Think through things that are likely to happen. Think through things that are likely to be ambiguous. It gives the sharks less to argue over and fewer temptations to argue. Part of my drafting philosophy and all this is, following that old biblical injunction: don't place a stumbling block before the blind. Don't put things into your agreements that'll tempt people to try to find ways around them. If it's there and in their hearts they know it's fair and they feel it's fair, then they'll probably follow it. And some of it does go back to the general advice I always give about partners. The most expensive mistake you can make is picking the wrong partner. And nobody can predict things in advance, but that's true about the way they'll treat your estate too, and the way you'll treat theirs, and what the expectations of their estate will be, and all that. We can put a lot of legalese around things, but we're talking about people and the way that they deal with money, and all of our legalese can only go so far.
It's great advice as always. Jeff, I can't thank you enough for the time, the insights. I appreciate it, my friend.
So thank you, Mike. It's good to see you, and see you again soon.
That's it for today's episode of Partnered Up, Business Law, Deals, and Dynamics. If you want to learn more, you want to connect with Jeff and the team, do me a favor, visit cl-lawgroup.com right now. And before you go, hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.